Thank you for joining us. My name is Connor Tucker. I'm chair of the Beverly Hills Bar Association's Appellate Law section, and I'm delighted today to introduce our speakers, Reid Ehrlich and Jerry Flanagan. Reid is an associate at Shernoff, Bidart, and Echeverria, LLP, where he focuses on law in motion and appellate litigation in insurance bad faith cases. He came to the bar through California Law Office's study program, and by the time he sat for the bar exam, he had already handled briefing in approximately 10 appeals. He's contributed to pro bono advocacy that resulted in the exoneration of a wrongfully convicted man through the Los Angeles County District Attorney's Conviction Review Unit. Jerry Flanagan is counsel at Shernoff, Bidart, Echeverria, LLP, with nearly 30 years of experience representing insurance consumers in healthcare policy, legislation, and litigation. He previously served as litigation director for Consumer Watchdog, where he led class actions resulting in $34.8 million in settlements over unlawful narrow network practices and argued before the United States Supreme Court on behalf of HIV-positive plaintiffs against CVS. He is an adjunct professor at Loyola Law School of Los Angeles, where he teaches health insurance regulation, law, policy, and politics. And now I'll pass it to them to get started.
Connor, thank you so much. I would just want to add that the LAFA study program that I participated in, it's an apprenticeship program that you complete in lieu of law school. And I completed that program as the apprentice for my father, Jeffrey Ehrlich, and he is a phenomenal appellate lawyer. During that program, I was able to see him argue more appeals than I can count. And that absolutely contributed to my understanding of what it takes to argue an appeal well and how to figure out whether you have a clear loser, a clear winner, or an appeal that could go either way. I'm really pleased to be giving this presentation with Jerry today. And Jerry, if you can take it away with framing the missions of oral argument.
Yes, will do. And just one piece of information about my background. Prior to being a lawyer, I was a lobbyist in primary state legislatures. So I bring that background and testified in probably about 100 or so legislative hearings, which is very similar to a appellate argument. And just to make sure that we have the record straight, that SCOTUS argument, Supreme Court, didn't happen because I was prepared and ready to argue about 2 weeks away, and the defendants gave up the ghost, and we won by default. So for big picture framing, a couple points here. One is that, and I think probably most importantly, is that oral argument is an opportunity to have a conversation with the court. And it should be really a participatory process, not one where you're pounding the table and they stay silent, right? Your job is to listen as much as you speak. And you'll hear us today talk a lot about listening well to the appellate bench. Now, we all know there's also something known as a cold bench as well as a hot bench. So you have to be prepared just in case there aren't any questions. It's pretty rare, but my approach always is to prepare an entire statement and outline as if it's going to be a cold bench and know it well enough that I can respond to questions as they come up. And, then that's really the key. You're there to answer questions. And sometimes we forget this because we're so focused on preparing our advocacy points that we forget that the number one assistance you can provide the appellate court is to answer questions that justices might have. And it is the case that justices come to the bench after reading the brief sometimes with actual questions. And you can see it on their faces. If they don't get their question answered, they get frustrated. And that's not a good thing for your case. Now, we all know also, I think that the reality is that often, whether it's the trial court or the appellate court, often the issues won or lost on the briefing. And I have to say that my colleague Reid Ehrlich is an outstanding brief writer, and I think he wins them all, probably almost all of them on the strength of the briefing. But, sometimes you don't know that, especially if there's no tentative. And there may be a justice or two that are on the fence, and really coming down to answering their questions well could win it or lose it for you. And of course, your prediction of what the justices are thinking will be most accurate if you can determine what kind of case you have, what we call a challenging case or a loser, a clear winner, or a toss-up. And, we certainly don't mean on a loser case that you should not do anything or just sit on your hands or give up. But what we're referring to are cases where you acknowledge that you've got really difficult law either against you or you need the court to create new law. The point is to know that, be upfront about it, and acknowledge those challenges as a way to kind of frame your overall argument. Now, Reid's going to talk about how to deal with those challenging appellate arguments when you have a tentative opinion.
Yeah, so the best way to know that you have a difficult case, what we are going to sometimes refer to as a clear loser, but as Jerry pointed out, you never know what's going to happen, and you should argue it as if you could prevail. There's no reason to just give up, but you want to be realistic. And the best way to know that you have a difficult case is if you receive a tentative opinion that's against you. And the reason for that is that courts rarely change their tentative opinions. And so if they do issue one and it's not in your favor, it's a pretty good sign that it's a good sign that you've got a difficult case. And what I'm going to do here is share my screen for 1 second to show you how tentative opinions might appear. Now, this is a tentative opinion that I received in a case that I argued called Palma versus Mercury. And this is not a full tentative opinion. As you can see, it's about 3 pages long. And that's it. And it's the court giving its thoughts on how the case is going to be decided, but it's not a specific opinion that goes through every component in a way that you would expect to see in an actual appellate opinion. And you can contrast that with what the 4th Appellate District, Division 2, issues in every single appeal, which is a full tentative opinion. If I scroll down here, you can see this just looks like a normal appellate opinion. It's just that it says tentative opinion here. And so you know that it's not an actual final opinion. And either way, whether you receive a full tentative opinion like this, or whether you receive something more akin to what I received in the Palma case, it's a sign that you've got a difficult case and you're going to need to be ready to prepare in a different way than as if you had, let's say, received a tentative opinion in your favor. Now, if there's no tentative, then it can be hard to figure out whether you've got a clear winner or a clear loser. A big part of that is just being honest with yourself and understanding if you've got a case with difficult facts, if you've got a case where there are already published opinions that go against you, then that's a sign that you've got a difficult case. But Jerry even has an example where you learn things on the day of that can make a case difficult.
Yeah. So what happens if you don't have a tentative opinion? That we're going to go back again to listen carefully again to the tone and the focus of the first questions from the court and adjust your approach as needed. And research your panel well in advance of the hearing. Have they offered opinions on the case in the past or similar cases? By the way, that's a great assignment for law clerks and law students. In some federal districts, though, not only you don't get a tentative, but for example, in the Sixth Circuit, at least they used to not announce the panel of judges until the day of the argument. And you have to be ready for anything. And I'll give you one example. I argued a Sixth Circuit Court of Appeal in Ohio, going back about 7 or 8 years now. And it's on Affordable Care Act case where the Affordable Care Act, the ACA or Obamacare, incorporated 4 civil rights laws into the ACA. And the question before the court was, does the ACA and these 4 provisions, do they provide a disparate impact cause of action as opposed to an intentional discrimination cause of action? And as I was walking into the court that day, I realized that the lead judge on the panel, Justice Sutton, had argued as a lawyer the counter perspective of my argument to the U.S. Supreme Court in a case called Alexander v. Sandoval. And this is again where you just have to know this stuff as well, cold. that, if you don't have the panel assignment in advance, I think that's becoming more rare, but there's still panels out there that you don't know and sometimes there's last minute changes. So you have to have that record cold. You got to know the cases really well. So what do you do in that kind of situation? Well, if you got three justices, obviously look to support from the other two. I knew in this panel, I knew the panels well enough that the other two justices were strict interpretationalists. So my immediate thought was, geez, I better focus on the words of the statutes for these two other justices because I'm worried about the lead justice here because of his prior argument and prior perspective. And of course, the other thing to do is, as to the person that you might have argued a different issue in the past, or in some cases written a different opinion in the past, obviously try to distinguish the best you can your case. The prior case that, in this case, Justice Sutton had argued was under Title VI, and I was talking about the Rehabilitation Act, and so that's a difference. I also knew that the prior case was based totally on stare decisis, and in those cases talked about how they didn't even look at the words of the statute. So putting that all together, I knew that my best argument there was, the past, stare decisis might bind the court to give sort of this atextual reading to the prior statute, but it didn't bind the court to make that kind of a reading on this case, because this case was about a different statute altogether. So I try to, again, distinguish the best I could, and also play to the strengths, or play to what I knew that the other justices were listening for. And, you need to be intellectually honest. Obviously, if you can't distinguish, you can't distinguish. And you don't want to tie yourself into knots and try to argue something that just doesn't play well, because not only are you going to lose, the one judge that you're worried about, you probably will turn off the other two that might be on your side.
Yeah, so I think what Jerry is getting at something really important here, which is when you're preparing, or if you find out something like on the day of that you've got a justice who has advocated the opposite of your position to the Supreme Court, you need to be realistic. If you have false optimism and you convince yourself that you expect that despite how difficult your case is, you're going to prevail, you're very likely going to be disappointed, and you're going to make tactical mistakes both in your brief writing and in how you prepare for oral argument, because your expectation shouldn't be that you're going to prevail if you have a very difficult case. Your expectation should be that you're not going to prevail. Maybe you'll be pleasantly surprised. Maybe the court will be more open to your position than you're expecting. But the expectation shouldn't be this is going to go great if you know that the panel is very likely not on your side, or if you know specifically that they're not on your side because you've received a tentative opinion. As part of being realistic, if you need the panel to make new law, or if there are decisions that already go against you, you need to acknowledge that directly and at the beginning of your argument. It is going to kill your credibility if you pretend like adverse authority doesn't exist, because you'll start talking and then the justices will interrupt you and say, but counsel, what about these other cases? And you'll have far more credibility if you grab the bull by the horns and you tell the justices from the outset, we understand that there's this adverse authority, and you're transparent about how maybe it goes against you, but there's still reasons why you should win. That there are ways to distinguish the authority, or sometimes there's just reasons why the authority is wrong. That the decisions that those opinions come to are not correct and should not be followed. But you need to be specific about what you're asking the panel to do if you're in that kind of situation. If you act like that doesn't exist, if you hide from adverse authority, it's not going to make you look good.
I think that, Reid, if I could just jump in there, is a critical point that Reid's making. Obviously, on these challenging cases, we're saying fight as hard as you can, but do it in the context of how it's going to be perceived. And also, as our colleague Ricardo Echeverria likes to say, throw the skunk on the table and be honest about it and be clear about it and construct your argument around that. And I think I stole your throw the skunk on the table reference, Reid.
It's a good reference. It's Ricardo Echeverria from our firm loves to say, let's get the skunk out on the table. And that is an important thing to do, particularly when you have a clear loser and there's a difficult issue that you're going to need to be able to overcome. And it brings up an example that I have in a case called Coast Restaurant Group versus Amguard Insurance Company from 2023. Coast was a COVID appeal that I argued where we were trying to get insurance coverage for a restaurant that had to close due to the shutdown orders in the COVID pandemic. And the question was whether the shutdown orders resulted in a physical loss of or damage to property. And when I argued that appeal, there were about 5 published opinions that concluded that the shutdown orders did not result in physical loss of or damage to property. And there were countless unpublished opinions from all around the country, not just California, holding that there was not insurance coverage for the type of shutdown orders that we were suing over. And the reason that I bring up this argument is I was able to make some headway with the justices by acknowledging that adverse authority and by finding the one case that every single one of the adverse authority relied on. And that way I could anchor my response to that authority using my best argument and summarily distinguish the authority and say, even if you look to those adverse cases, they all rely on one case that doesn't apply here. And specifically, each one of the published opinions that I was arguing against had relied on a case called MRI Healthcare versus State Farm. MRI Healthcare, as you might imagine, dealt with an MRI, and the company that owned the machine had ramped it down, had demagnetized it so that it no longer functioned. And then when they tried to ramp it back up, it failed, and they were suing for insurance coverage over that. And the court in MRI Healthcare held that for there to be a physical loss to property, there needed to be some external force acting on it that resulted in damage. And the distinguishing thing in MRI Healthcare was that the insuring agreement didn't include the phrase loss or damage. It only included loss. It said physical loss. And the court in MRI Healthcare decided that loss essentially meant damage, that they were the same thing. That was different than the insurance policy in the Coast case, which said that there had to be physical loss of or damage to property. And because it was written in the disjunctive in that way, loss needed to mean something different than damage, or there would be surplusage in the insurance contract. And so by pointing out that distinction, I was able to distinguish all of the adverse cases in a quick and effective way. And the court in Coast actually ruled in our favor on that question and held that there could be a physical loss of or damage to property from the shutdown orders. We still didn't win the case because the court ruled that there was a virus exclusion that precluded insurance coverage. But it shows that you should show up and do your best to argue, even when you think you have a difficult case, even if you think it's a clear loser, because you really never know what's going to happen. Those arguments that I had made about physical loss or damage to had been made in the other cases as well, had been made to the court and simply rejected. But that day, in front of the panel that I was arguing in front of, they were more receptive to that position than other courts had been. And you never know if you might be finding yourself in a situation like that. So another thing to remember when you're preparing for oral argument in a difficult case is that your goal may not be to win outright. That may not be an attainable goal. Sometimes you want to limit the scope of the adverse ruling. You want to make sure that even if you lose, that the court issues hopefully an unpublished opinion, but if published, a very limited ruling that's very dependent on the facts and specific to the circumstances of the case. Other times, you may want to obtain a very compelling dissent, even if you don't think that you will convince 2 of the 3 justices. Maybe you'll get 1, and then you'll be able to effectively ask the Supreme Court to grant review and revisit your case. Maybe you're not even sure if you'll get a dissent at all, but you'll be able to convince the justices that there's a lack of clarity in this area of the law, and they may ask the Supreme Court for guidance when they issue their opinion. And that brings me to another example. It's an appeal that I argued. It was called Carr versus City of Newport Beach that I argued in 2023. And in Carr, there was a young man who was at a beach in Newport Beach, and he walked out on something called a groin or a seawall, and it's a wall that is designed to prevent beach erosion. It keeps sand on beaches, but it sure looks like a platform for someone to just walk out on and jump off of. And so our client, Mr. Carr, walked out onto that seawall and dove off of the seawall into the ocean, and he struck his head against the ocean floor and he broke his neck. So we sued the city of Newport Beach saying that that was a dangerous condition of public property because it looked like something that any normal beachgoer would be able to jump off of safely, and it was something constructed by the city. The problem that we had in that case is something called hazardous recreational immunity. And that's a doctrine that exists regarding public lands that says people like to use public lands for hazardous activities such as motocross or surfing or skydiving, and that people enjoy those activities and should be allowed to enjoy those activities. But if people get hurt while participating in those activities and they're allowed to sue the government for, a motocross area that's not in perfect condition, or for going on a hike on a trail where they slip and fall, the most likely response from the government is simply going to be to cut off access to those public areas and not allow anybody to use them anymore. And so the deal that the law strikes is that people can use those public areas for those hazardous activities, but the government is immune from injuries that people experience while they're participating in those activities. And diving is absolutely one of those hazardous activities. And so we lost in the trial court because our client had unquestionably dove from the seawall into the ocean, and that was the cause of his injury. If he had not dove into the ocean, if he had not, jumped head first, then he wouldn't have been injured in the same fashion. And we presented our arguments that any normal person seeing this wall would think that it was a diving platform, would think that it was something that was built specifically for people to dive off of, that there was a pier next to it that had no diving signs posted on it, but that there weren't any signs posted on the groin. And so someone could conclude, well, I'm not supposed to dive off the pier, but that's why they've built this other structure and platform for me to use. And again, we did not prevail in that case. We did obtain one dissent, but we also got the court to ask for guidance from the Supreme Court. In a published opinion, the court said the application of this statute that creates hazardous recreational immunity is unclear, and we would benefit from guidance from the Supreme Court. We wrote a petition for review that I thought was very persuasive, given the court's request for that. It ultimately was not granted, so we achieved what we were hoping for in the appellate court, at least in terms of getting a dissent and in getting the court to ask for guidance. Our ultimate goal of getting review didn't ultimately pan out, but still, that was a good result in an oral argument where things were very likely not going to go well. We at least obtained something that helped us at the next level in some fashion. Now, when you talk about the actual argument itself as opposed to preparation, again, you want to argue your position vigorously. You never know what's going to happen. And so no matter how many published opinions there are against you, don't give up. You don't need to concede that you're wrong on anything important, but also don't lead with weakness. Don't pretend that weaknesses don't exist, but don't lead with it. You want to lead with your strong points and then be able to deal with the weaknesses as the justices ask your questions. So again, as Ricardo Echeverria at our firm likes to say, you want to get the skunk out on the table and acknowledge to the justices, these are the difficulties in our case. This is the adverse authority. Use concessions strategically. If a justice asks you a question on a point that you don't need to win early on, admit it. Tell the justice that they're right and concede that point if it's not essential. In doing that, it'll build credibility. The justices will know that if you're dying on a hill that you really have a point, that you really believe there's something to be said there, as opposed to that you're just willing to argue every tiny little point, and will just kind of reflexively dispute things. That's not going to be a way to build credibility with the justices. And building credibility is probably the most important thing that you can do early on in your argument. Another thing is your demeanor. It's hard to argue a case that you don't think you're going to win. It's scary and it's difficult to do it enthusiastically. You don't need to do it with a giant smile on your face, but you do want to present your position in a respectful way that's clear and easy to understand. You're going to need to understand that the justices are probably going to disagree with you. They're probably going to ask you questions that are pointed, that are designed to illustrate why you're wrong. And be prepared for that. Be prepared to take those in stride and to explain to the justices calmly, in a cool and collected manner, why you should still win, why you still have a valid point. And the best example I can think of this is another COVID case, and one that my dad argued. It was called Musso and Frank Grill versus Mitsui Sumitomo Insurance Company. And that was a little earlier in the history of COVID appeals. There were only about 2 or 3 published opinions. It's a little earlier than the Coast argument that I had. But it was a difficult position that my dad was defending. And he did it in such an impressive way. It was early on in the practice of remote arguments, and so he was kind of struggling initially to get his camera on. He joked with the justices about them seeing him. He didn't hide from any of the adverse authority. He actually did argue with a smile. And by the end of his argument, Justice Cheney told him, "I give you an A+ for your presentation." Now, he didn't win. They ruled against him, and they actually issued an opinion against him the day after oral argument. So there was no mystery that he had not convinced them of his position, but they clearly were impressed in the manner that he had argued. And if you argue a difficult case, if you argue a clear loser, and the justices compliment you like that at the end, you should feel very, very good about the job that you've done. To that point, don't get beaten down. You're going to get some tough questions. If the justices ask you about some authority that contradicts your position, you should acknowledge that. You should say, "That's true. We disagree with those opinions," or "They're distinguishable for these reasons." You can even say, things like, "I understand that one of the justices doesn't agree with our position." That doesn't mean that you're conceding defeat. You can just acknowledge that there's difficulty in the position that you're presenting without saying, "But you're right, I'm wrong." There's no reason to ever say that during an oral argument, unless it's a point that you want to concede that you think is not very important. For the important points, stand up for yourself and, don't beat the table, but defend them vigorously. It's an important part of arguing with grace, is knowing the points that you still need to be firm on, even when the justices make it clear that they're disagreeing with you. And last point about arguing clear losers is that you want to make a good impression. You want to avoid desperation tactics like attacking opposing counsel or making frivolous arguments. Civility is going to be your most effective way to argue. It's going to give you credibility, and it's more likely to lead to the justices remembering you in a positive way in future appeals that you argue.
Yeah, I would say be the happy warrior, right, Reid? I mean, civility is not only your duty as a lawyer but for the court, but it also is your strongest form of advocacy. I mean, that civility in the face of adversity it inspires confidence in the ear of the listener, of the righteousness of your position. If there's a tone of like, if you start to, get behind in an argument and it starts to you hear an edge in someone's voice, it kind of sounds like defeat. But at least I felt like I've turned justice around just by remaining calm and civil, and have a good time while you're arguing and do your best to turn deal with a substantive issue. And I was going to talk now, read about the clear winners, but I also wanted to just note James asked the question in the chat. And this is something I was going to get to later, but it's a good place here. And James notes that in the U.S. Supreme Court, advocates begin with a very short summary, 60 to 90 seconds of their argument, and then simply solicit questions for the court. And James asks, do you think this approach would work in the California Court of Appeal? And my answer is yes, as long as they actually give you 60 to 90 seconds, right? So the one thing I was going to say later is like a great way if you're new at appellate argument, or even just new to sort of trial argument in general, is just to listen to a bunch of arguments at the U.S. Supreme Court. And they've got a great archive on the website. You can listen to arguments going back 20, 30 years, maybe even longer. And James is right. There's like a 60 to 90 second opening statement that is sort of the tradition of the U.S. Supreme Court. Now, I can't guarantee you that every Court of Appeal is going to realize that you're invoking that tradition and not interrupt you. But I do think I recommend that write out your opening 60 to 90 seconds. Don't read it, but have it memorized or have it enough in your head that you're ready to go with a very compelling opening that, as Reid says, if you got a tough one, acknowledges the difficulties, but says why those prior cases should be turned around or why no new law is necessary. So again, I think it's a great approach. I think everyone should prepare for a 16 to 90 second opener that is your best summary. And because I'm a paranoid person worried about like, what if I got the coldest bench in the world, and no one asks anything, know what you're going to say to fill the silence. Now, does that ever happen? Probably almost never, but I do prepare kind of sort of three different versions. One is just a short 60, 90 second opening, another version, which is that I'm immediately answering questions, and another, the full outline of here's everything that I would say in the unlikely event or the event that, no one asks any questions at all. So we'll keep getting to the questions that we go through, but that was a good one. Reid, does it make sense now for me to talk about clear winners?
Yeah. So for clear winners, Jerry, I would say the only way to know that you have a clear winner before argument begins is if you get a tentative opinion, because if you don't receive a tentative opinion, then you should be prepared to argue either way. But if you don't receive a tentative opinion, I think you have some good examples for us to learn about.
Yeah, so you're going to talk about what to do without spiking the football when you get a tentative in a minute. But what happens, if you don't have a tentative, and so you really don't know? Again, we're going back to listening. What is the tone at the beginning of the argument? And really pay attention. And that's easier to say than to do sometimes, because especially if you're new to oral argument at the appellate level, the nerves and the adrenaline's pumping. And what can sometimes happen is you're so focused on that outline you prepared, and you're so worried about the hardest question that you thought you might get, that you sometimes miss the softball. You miss the fact that the question coming is one in your favor. It's one that kind of goes to the heart of your case and asks a yes or no. And that's usually a pretty good sign that the justices are going your way. You got to hear it, and you got to have, as one of my former partners used to say, listen with fresh ears, which I thought was a funny comment. But what that means is that you got to step away from your preparation when you step up to the podium and really listen to that first question to get a sense of where it's going. And sometimes they may be softballs. Sometimes you might have a clear winner, even though you didn't know, but the panel's with you. Don't snatch defeat from the jaws of victory by going to the wrong argument. And I had a couple examples on the outline here. Notice that I didn't put any case names in, because I think these are kind of like a little bit more embarrassing ones. But I saw an auto insurance case a few years back where, without going into the details, the opening question was just kind of this softball question that went to the heart of the case, and the attorney was just so, I think, worried and nervous about the hardest argument that they were hoping didn't come up. They couldn't help themselves and went immediately to talking about the worst argument the other side could raise. And I did feel like it did sway the justices in the wrong direction, right, toward the, the other party's position. So again, it's easy to say, hard to do, but really get in the habit of listening to, and you really got to work on listening well and listening for where there's no tentative. What is the tone of this opening question, and is it telling me that it's going to go my way? Another example, a health and care rescission case. Two points here. If you don't have a tentative, you don't know if it's a clear winner until they start asking those questions. So the best thing you can do, be prepared. There was an oral argument, and this one I had to pick my jaw up off the ground. I was going just to watch, and it was on a healthcare rescission case. And I'm not joking. As we were going through the security at the Court of Appeal, the two attorneys for the plaintiffs were, I wouldn't say arguing, but discussing who should do the oral argument that was about to happen. So literally, I hadn't decided yet. I just couldn't believe it. So obviously that's an extreme example, but be prepared, right? Don't wait to the last minute to figure out who's going to argue, and especially if co-counsel or another colleague in the office. And I think it's a good point to where there's no tentatives on these cases and just in general to talk about planning. If you have co-counsel, decide early on who's going to write the brief, who will argue. My view is, and I think it's pretty common, that whoever writes the brief should argue it, but it's not always that case. Is it a fact-intensive case that, and if so, is it like an MSJ where it's all about this deep factual record? Who should argue it? That's the best way to set yourself up for a victory. And if that person doesn't want to argue it, then who has time to learn the record well enough? And be really honest about that. Like, do you have time really to dig in to get ready for an appellate argument? And don't assume there's agreement between co-counsel. I've seen a couple times where prior law firms where they, I think some people think that they're the one that's going to argue, and then it turns out someone else thought it was going to be them. And you don't want to have like a disagreement like that, a distraction at the last minute. Prepare early, set yourself up for success. And I will note that there's also another thing that you should talk about early with among your team or with co-counsel, is that should you hire appellate counsel? And that's usually a big question on appeals, and it can be costly to hire appellate counsel, but sometimes it's just worth doing it. And there's another area where you just got to be honest with yourself. Do you have the time to do it? Are you new? And if so, if you're new in this area of appellate law, think about it this way: bringing in appellate counsel and sort of co-counseling or co-chairing the appeal is a great way to learn from from your colleagues out there in the community that just are just much more experienced than you are, and that could be a great opportunity to do so. And then just keep in mind, in terms of the appellate brief writing as well, it's a very different process, right, than writing a trial brief. And arguing appellate briefs and appellate arguments are just very different than trial arguments or trial court arguments. Obviously, the appellate briefs generally demand a narrower record-bound strategy that focus on identifying the reversible errors. And I've seen a lot of times an oral argument where things that could have been clear winners, or where the justices are with them, the counsel that's up there is not focusing on his argument on a sort of an appellate approach, and focusing on anticipating arguments on the other side that are going to the reversible legal error issue that are real more apropos toward the appeal.
I have I just want to jump in here for a second, Jerry. Jerry's right that considering whether you want to hire appellate counsel is a critical issue, because the rhythms and timing of trial practice versus appellate practice are very, very different. When you have an appeals or briefing is generally due 30 or 40 days after each successive brief, but in the Court of Appeal, you can obtain 60-day extensions essentially every single time for every single brief that you're going to write. They're so easy to obtain. The court issues them so frequently that everybody stipulates to them. At least they do if they don't want to look bad in front of a court for not, so that they don't have to make their opposing counsel go and get an extension from the court. So appeals often will take years if just because the briefing is going to swallow up an incredibly long amount of time. And you need to be aware of those long kind of horizons because oftentimes it feels like something's not really due, and then all of a sudden you've got an appeal that's due very quickly, and you were supposed to have been working on it for the last 3 months, and it requires you to summarize the record and to do a substantial amount of legal research. And if you're trying to do that on a short timeline when you're trying to deal with other cases and trial at the same time, it's not going to work very well. And so just understand that the deadlines when you're handling an appeal can be very different. A quirky thing about the Court of Appeal is that for your opening brief or for a respondent's brief, if the day comes when you're supposed to file it and it has not been filed, the Court of Appeal, once it notices that you didn't file something, will send you a letter and say, you didn't file something on time. You now need to file it within 15 days. And if you don't file it within 15 days, then you're going to forfeit your rights to the appeal. So things are actually almost always kind of due 15 days after you're most worried they're going to be due. But it doesn't apply to reply briefs. So it's just something to keep in mind there. The other point I wanted to make is if people are arguing about who should handle oral argument, pick one person to handle the oral argument. I've seen multiple attorneys try to split up oral argument, and it never goes well. Jerry, I'm sure, agrees with me. It just results in kind of a scattered presentation, and it frankly takes up a lot of time when you're switching, when someone's sitting down and someone's standing back up. It takes up valuable time. So when it comes to preparing for a case where perhaps you've received a tentative opinion in your favor, Jerry's right that you don't want to spike the football. We all want to bask in the glory of victory, but oral argument's not the time to do that. And if you try to re-argue points that the court has already accepted in its tentative, you're actually more likely to do harm to your position because it's going to invite questions that the court doesn't need to ask you, but instead you're causing them to rethink their position, and then they may change their position based on you getting them to revisit it. You do, when you're preparing, you want to identify the arguments that your opponent is likely to use in trying to attack the tentative. It's the best way for you to prepare for the arguments that are going to come up. Instead of trying to predict the justice's exact questions, if you have a tentative in your favor, think of what are the potential weaknesses in the tentative that your opponent is likely to pick on. And also think about what is the hardest possible question that the panel might ask you, even though the tentative is in your favor, because they often like to probe the limits of the position that they're taking in an opinion. So know where your argument stops so that you can tell a justice, Your Honor, that's not actually a problem that you need to be worried about. We're only asking you to rule this far. We're only asking you to rule X. Now, during oral argument, the most important thing, if you have a tentative in your favor, is efficiency. The panel already agrees with you. So address their concerns and then get out of there. Sit down.
Don't snatch defeat from the jaws of victory, right?
Exactly. You want the argument to be uneventful. If there's a tentative in your favor, you want it to be uneventful. And you want to be confident, but don't be arrogant. Again, exemplify civility. If you've essentially already won, then sometimes there's not a lot for you to do. Sometimes when you have a tentative in your favor, you may not argue at all. If the panel has a lot of questions for your opponent, and then you stand up and say, are there any questions for me? And they say no, the best thing to do may be to sit down so that you don't re-argue any position that they've already decided in your favor and you don't waste their time.
And keep it simple, right? Because I think you pointed out. I remember right, I talk. The more you talk on a case that you've got in your favor with a clear tentative, the more likely are you to say something that's going to raise a question in the other direction, right? You might
Yeah,
clarify something in the wrong direction for one of the justices.
you don't want to goof up that way. You don't want to use long summaries. If the panel's already on your side, then it's better to demonstrate that you understand the key issues and then quickly address your opponent's points instead of these kind of long, overarching summaries. That's not going to be efficient. That's going to take up the panel's time. And finally, know your stopping point. You may not need all your time, and so craft a crisp and confident closing that you can deliver at the end to leave on a high point, and that'll be a better way to end your argument than taking up all the time in an unnecessary fashion.
Hey, Reid, can I address two questions in the chat that are kind of apropos to what we're just talking about?
Yeah, go for it.
So Erica, she asked a tough question, and I think it goes to the civility issue, but not only with the other side, but with also the trial court. She asks, can you speak to the circumstances wherein you are not in agreement with the decision below, which is, I mean, you lost to the trial court, right? And you're struggling to maintain respect toward the court. And I think we've all been there. You got to be really careful just not only cast shade at your friend on the other side of the aisle, right? The counsel either for the plaintiffs or defendants on the other side, but also don't cast shade toward the trial court as well. You got to characterize that decision as clearly and as simply as possible, and just stay out of anything that sounds like a personal attack. Obviously, focus on why it's wrong legally and how the court got it wrong on the cases and the case law, not as opposed to they just something didn't understand or didn't maybe didn't have the certainly not the cognizant tools to deal with. I do recall watching an appellate argument once where the lawyer was implying that the trial court wasn't very smart, and I just don't think that works very well. Justices know each other and stick to the law, and it can be hard sometimes. Should I talk about the toss-ups now?
Yeah, I think so. There's one other question I want to briefly address from Jack. He says, "Are you role playing with AI ahead of argument?" My short answer would be no. I am not role playing with AI, but I do think role playing is a valuable thing to do. You want to mock up the argument that you're doing, but I would do it with other lawyers that you respect. Doing it with AI might be helpful, but doing it with other lawyers is going to be more helpful because you're going to get a more authentic experience and actually being able to going through the motion of pausing and answering a question is going to be really valuable preparation just so that it's not a foreign process for you when the actual argument begins.
Right. And that was the thing I was going to address. I saw Jack's comment too, but obviously on the toss-ups, I mean, that's where, if you don't have it's a close call, legally just from the drafting. And sometimes you learn about, if the other side gets a different appellate counsel and you think that, geez, their appellate argument is a lot better than it was in the trial court and things are looking more even and you don't have and you're also in your court that you're not going to get a tentative or you're pretty sure you're not going to get a tentative, moot it. I'd be curious though, if the questioner right now, was it Jack? I think it was Jack. I'd just be curious if there's a product you're aware of that does AI moots, but I would definitely do real moot arguments and do it with people who ask tough questions. It's like I was getting ready for that U.S. Supreme Court argument. You do lots of moots, and it's very helpful, obviously, to do that. So I see a couple. I'm going to start talking about. I see another question from Erica. We'll get to that in just a moment, but I want to talk just for a few minutes about toss-up. So what to do when you have got a case that's right on the line. This is obviously where oral argument can make or break your case. So you just got to prepare, as comprehensively as possible and be as nimble as possible. Again, if you're going to a case where you know that just based on the briefing, it's a close call, and you really do got to step out of your, strong advocacy for your client once in a while and try to read those briefs and come to the argument with sort of a clear understanding of where you're at legally and just how close the argument might be, and acknowledge that. Sometimes if we drink our own Kool-Aid, or we in other words we kind of buy our arguments too much, and we don't read the other side's brief as close as we should, and try to read it from a sort of a perspective of a judge coming to it with a neutral mindset. Or when you learn your panel, maybe that panel may read that the trial court opinion and also the briefing of the other side differently than you had. So take that all into account as you're getting ready, and it could very well be that you're going to see that this is going to be more of a toss-up. So one of the things, again, on a toss-up, obviously you have to do is you have to just, where it's a close call, going in, it's going to be a fight. You obviously have to know the record backwards, and you have to know the law backwards. And I'll just put a footnote in here. Think about that early. Again, if you can't do it, and as Reid said earlier, if your trial schedule coming up is going to keep you from preparing for the oral argument or writing the brief, get co-counsel and do it early. Don't wait to the last minute. The other thing I think is really important to do is not only preparing your argument, but prepare yourself intellectually and also get used to the format you're going to be arguing in. For example, I much prefer doing in-person arguments. And if you're going to go to a new court of appeal on a tough argument, or even one that's not a tough argument, but any of them, I would say, go check out the court ahead of time. Go listen to an argument. You don't want to be distracted day of by, hey, the echo in this room is a little different, or look at that interesting dark paneling. Like, you want to kind of get a feel of the room, get a feel for what the setup is. Similarly, I had a case a couple of years ago, right in the smack of, actually very early in the COVID period. It was in 2020 at the Ninth Circuit, in another case similar to the one I was at the Sixth Circuit on the ACA Affordable Care Act. And it was the first argument I had ever done on a platform, on a video platform, because I think it was early. We all did our best at that time. It seems funny to say now that that was the first argument, but at that time, there weren't that many video appearances. And as much as we practiced, I remember being just sort of really, like, I think your dad, Reid, you said one time, one of the arguments was just distracted by the video nature of it. And I know now that a lot of us are becoming much more accustomed to doing video appearances. But two thoughts. One is, check out the platform your court's using, because I have noticed that sometimes the courts will use, maybe a platform, especially that you have not heard of, if you're out of state in particular. Practice with it, because I got surprised on one where it just operated differently than the Teams and the Zooms that we're used to. I think it was called Blue Jeans or something like this. I don't actually recall what it was. Just different. So don't forget that part of the preparation. And really, maybe do a moot. If you're going to do a moot, or if you're going to do the oral argument on a new platform, maybe do the moot over that same platform so you can get used to it. And again, if you've been, I just will say, if you've been doing a lot of video arguments and you have the opportunity of doing in person, I know others will disagree possibly, but I really do think that if it's a close one, I always want to be in person if I can, because a lot of it has to do with how you convey and making sure that you're connecting with the justices and they're really understanding if there's a nuance to it, the nuance. I've been surprised how well things have gone over video, because sometimes, like especially during the COVID, we weren't allowed to do oral arguments in person. I thought, oh, well, I got to do it. And it worked out fine. We won a lot of them, right? But, on the toss-ups, I really would consider in person. My view is that it's the better way to go. So again, what to do on a toss-up? You got to know the record and the law backwards. That's just a given. I would consider also writing out, like typing out every question you can think of, and if you have time, what I do is I'll type out every response, and I'll try to get it down to concise form. Not because I'm going to read it, but I find that the best way to prepare for oral argument is redo my outline a bunch of times, go through it, edit it, and go through and edit the questions, because that's just how it gets into my brain. Just going through it a bunch of times and writing out, forcing yourself to go through the unpleasant task of writing out the answer to every tough question you can think of. And can you do it in 3 sentences? Can you get it that simple? Can you do it? And also have a flexible outline for the toss-ups, right? And adjust your presentation depending on what you're hearing from the courts. Is the court with me and doesn't need to hear more on that? Or is it going to be problematic? I need to be available to provide more detail on certain points. So I'll pause there. We can, and I see that it's 1:25, so we can maybe do some more questions if we have them. I see one here from Erica, and maybe Reid, you have some thoughts on this too. And Erica asks, in asking for the petition for review, how often does it result in legislative changes? Alternatively, should you then pivot to legislative drafting? Conversely, can you do a subsequent CLE on legislative advocacy? Sure, we can. That's fun. I mean, that's one of the things you learn about your case sometimes. Like, and it's not necessarily you made a mistake necessarily in the trial court, but things evolve as the appellate argument evolves. And sometimes I've had requested legislative history on an appellate argument that I didn't think I needed in the trial court, and as I have been getting ready for that appellate argument. All the time, I keep a different Word document open called legislative changes we need, right? And just take notes on that as you go, because sometimes that is how to best be an advocate for your client. Is not only do we have to win this appeal, but we also have to maybe write some new law that's become more clear in your mind as you're facing these really tough arguments from the other side in preparing for appellate arguments.
I see there's a question from Erica as well. What are your thoughts on conditional waivers of oral argument? Just in terms of waiving oral argument, I would say if you were the appellant, I would not do it. Because you're coming to the Court of Appeal, asking the court to change something. And so waiving oral argument as the appellant is a lot like waving the white flag and admitting that you no longer believe in your position. Conversely, if the other side waives oral argument, then and they're the appellant, if you're the respondent, then that's fine. You don't need to insist on there being oral argument if the other side is willing to give it up. I think primarily because the fact that they're willing to give it up is generally a sign that they don't really believe in their position. So in general, I would not waive oral argument unless the other side is waiving oral argument and is the appellant.
I see it. By the way, Jennifer writes in the answering our question from before, there's a moot program called Your Honor AI. I'll check it out. I have to say that I'm with Reid. I would definitely try to organize some moots with live people, and particularly lawyers that know the substance really well, that aren't going to be easy on you. I mean, and then check out Your Honor AI and then compare and see, Josh, did it really get to the tough questions that I was worried about? Interesting. I never even heard of that before. So yeah, we're about out of time. I'm just signing here.
See, is it okay to use family members / non-lawyer friends in your practice? Absolutely. Use whoever you have access to, and your non-lawyer friends or family might be able to think of things in a different light than you have or that your lawyer friends have. But I would also try to do it with at least one lawyer, just because that attorney is going to be more likely to understand the actual issues in the appeal and is going to be more likely to ask questions that are akin to a question that you're going to receive from a justice. But the more perspectives you can get and the broader perspectives you can get, it's better, the better.
And we'll petition to come back if you'll have us to do a legislative advocacy CLE, because I think that'd be a lot of fun.
Yeah.
Alrighty, this concludes today's presentation. Thank you so much, Jerry and Reid, for an excellent presentation, and thank you so much to our audience. Have a great day, everybody.
Thank you, guys.
Thank you.